Welcome to AZL's session on teaching international law to non-legal audiences, put together by AZL's Teaching International Law Interest Group. My name is Iveta Pike, and I will be the moderator for this session. We have a wonderful panel with distinguished colleagues with varied experiences in teaching international law in non-legal settings. Before we start our conversation about this topic, I would like to go around and for each of our distinguished guests to introduce themselves. Maybe we can start with Greg.
Thank you, Iveta, and thank you, Azel, for inviting me. It's an honor to be on such a distinguished panel with my colleagues here. My name is Greg Noon. I spent 30 years as a United States Navy judge advocate, retired as a captain. And also along those lines, I've been teaching at university for the last couple of decades, both in undergraduate, graduate, and law school. And lastly, I've been with the Public International Law and Policy Group for the last 20 years, as well as a senior peace fellow.
Vanessa.
Hi, my name is Vanessa Montague. Hi, my name is Vanessa Montague. Thank you, Beta. Thank you, Asel, for this invitation. I am an attorney specialized in international human rights law. I'm also a political analyst, and I'm a law professor. I've taught at several universities in Latin America, including the University of the Americas, UDLA, in Quito, Ecuador. And for the past 12 consecutive years, I have worked for the U.S. Embassy. I currently serve as a senior political specialist. Part of my duties as political specialist is to monitor programming funded by the Department of State's Bureau of Democracy, Human Rights, and Labor, more commonly known in the Department of State world as DRL. Part of the programming and assistance that DRL provides is training on a variety of topics, including international law. And I will discuss that more in length in the next segment. Thank you.
Hello, everyone. My name is Hardy Veer. I am the Senior Vice President of Legal at Human Rights First, an NGO with offices in New York, DC, and Los Angeles. I've been with the organization for about 6.5 years. I lead our team's refugee representation work, where we serve asylum seekers in the United States, looking to secure asylum for themselves and oftentimes their loved ones. And in addition, I lead our impact litigation work, which involves us bringing lawsuits primarily against the federal government to try to create systemic change when it comes to asylum issues. And there we often rely on international law, or to the extent we can rely on international law, we will put those arguments forward. In addition, I teach at the University of Michigan for the last 4 years. I teach international law to graduate students and upper level undergraduates. And like Dr. Noon, I had the pleasure of serving in the United States Navy JAG Corps once upon a time. Pleasure to be here.
Hi, I'm Julie Rocinos. I'm an advisor to the Chief Justice of the Supreme Court of Mexico, Arturo Saldívar Lelo de la Rea. That's my current position. Before that, I spent 11 years at the Inter-American Court of Human Rights, where I was a senior coordinating attorney. At the Inter-American Court of Human Rights, basically we were tasked with advising the judges and writing the draft judgments on contentious cases that came before the Inter-American Court, which has jurisdiction over 21 states of the Americas. So that's where the places that I have worked, and we'll talk about the teaching in the next question. Thank you.
Thank you so much for this great introduction. As I mentioned before, we have a wonderful set of experts to speak to us today. Before we jump into the first topic, I just wanted to say that normally when we think about teaching international law, most of us are thinking about law students, judges, and other law professionals. However, our session today will be focusing more on the importance of teaching international law to non-legal audiences. So perhaps staff at international organization, politicians, diplomats, military, refugees, and so on. So our panel will address who the non-legal audiences are in their or where in their work, what are the benefits of teaching international law to such audiences, and lastly, we'll talk about what opportunities are there for those of you who are interested in getting involved in teaching international law to such audiences in the future. So without further delay, I would like to each panelist maybe to describe in the context in which they taught international law, who their audiences, non-legal audiences were, and what was challenging to them, because it's a little bit different than teaching legal audiences. So maybe we can start with Vanessa.
Thanks, Iveta. Sure, it will be a pleasure. Before I go into explaining how international law has been taught from my experience, I'm just going to explain briefly the purpose of DRL. DRL was created in 1977 to advance individual liberty and freedoms around the world from the Department of State's perspective. DRL has a variety of programs, including foreign assistance and public outreach programs. And through those programs, we find training opportunities to CSOs and human rights activists. And there are times when those activists do not have a legal background and require training to implement initiatives meant to strengthen rule of law within their respective countries. There are also cases where local CSOs and activists require assistance in learning new concepts that often emerge in the field of international law. Training non-legal audiences becomes relevant from that perspective when human rights defenders require tools to advocate against laws that somehow restrict the freedoms, such as freedom of association, assembly, expression, and do not comply with the standards set by international law, or somehow constrain the operating space for human rights defenders within their respective countries. So DRL decided to design projects, including training opportunities through third organizations responsive to a country's needs and priorities, because they are created with local input to leverage windows of opportunity and reflect current political context. DRL projects successfully contribute to improving justice systems and institutions worldwide. Thanks to training opportunities, non-legal audiences obtain tools to ensure fairness and access to justice. Now, this type of training opportunities include practical implementation and interpretation of a specific laws that indirectly or partially advance international human rights standards, but more importantly, greater government accountability around the world. Training non-legal audiences also helps empower groups and individuals in addressing controversial or politically sensitive issues, for example, say environmental protection, domestic violence, disability rights, or women's rights. We often, when we think about international law, we often think just about the obligations that states have. But international law is obviously much broader than that. Another training program that I personally believe that the Department of State has that promotes training and more knowledge to specific audiences, including topics such as international law, is the International Visitor Leadership Program called IVLP. It is a US Department of State's premier professional exchange program. Through short-term visits to the US, current and emerging foreign leaders in a variety of fields experience the country, the United States, firsthand, and cultivate lasting relationship with their American counterparts. Professional meetings reflect the participants' professional interests and support foreign policy of the United States, but more importantly, we just help raise the bar of international law and international human rights law. Each year, nearly 5,000 international visitors come to the US on International Visitor Leadership Program. More than 200,000 visitors have engaged with Americans through the IVLP, more than 500 current or former chiefs of state or heads of government too. This kind of changes also help selected individuals who do not necessarily have a legal background to understand some of the concepts in international law during their visits to the US. Additionally, and per the request of local organizations, and this is separate from IVLP, in host countries, U.S. embassies sometimes may bring into the country, host country that is, experts who train non-legal audiences in specific topics, including international law. So I have not personally taught international law to non-legal audiences. I have taught international law, but to law students in Latin America. However, from my experience in monitoring these programs run by the Department of State, and because I have accompanied experts to these workshops and training sessions, I can say that most of the trainings begin with an introduction to the topic that trainees require more tools in. Let's say, for example, religious freedom. Then the trainer begins to raise questions to engage participants, and we began to facilitate the exchange of ideas, best practices, etc. Sometimes the trainers also break non-legal audiences into smaller groups to facilitate discussion and find practical solutions to the problems that they face. As for teaching methods, are we going to discuss that right now, Iveta?
We can pick up later, but if you have something that you feel that that it was something particular that you think that came up in your experience, you can raise that now too.
So basically, all I'm going to say right now is that I personally recommend, from my experience in monitoring these programs, the best teaching method is definitely case studies, because students become the solvers of the problems. And they sort of transfer from that passive role into that active role, because they begin to construct solutions based on the tools that they have available. But I'll discuss that more in the next segment. Thank you, Vera.
Thank you, Vanessa. So maybe we can move to Greg, and Greg can tell us about his experience. I understand he was teaching to different audiences, including military. So we are very interested to hear about that. Thank you.
Yes, thank you, Iveta. So in the last 25 years, I've traveled to more than 60 countries and trained foreign militaries and government officials, as well as NGOs and IGOs. Primarily through the Defense Institute of International Legal Studies, whose job is, in the Department of Defense, is to conduct human rights training and law of armed conflict, international humanitarian law training for any foreign military that's receiving any foreign assistance from the U.S. military. So whether that foreign assistance is special forces training, a box of hand grenades, a fighter jet, whatever it is, it's a congressionally mandated training that requires that unit to receive the human rights and law of armed conflict training. Concurrently with that, I've also worked with the Public International Law and Policy Group, which is really a kind of a global pro bono law firm, and we do a lot of work in post-conflict environments, peace negotiations, et cetera. And one of the areas we've worked a great deal in is human rights documentation. We led the effort in the refugee camps in Bangladesh on what the Myanmar government had done to the Rohingyas. And we continue to work with the human rights documenters in the camps, training them on what are the necessary things that they need to gather. What's the information that they need if they're going to pass it on to an international body. So all of it being very practical. How do you apply what you're doing and stay within the limits of international law? And lastly, I've been teaching undergraduates and graduate students, as well as my share of law students, but they're not nearly as fun as the undergraduates in international law as well. And with all of this, one of the things that I think is critical is making it relevant to them both personally and nationally. How does it affect them personally? So whether you're talking about an undergraduate and they're traveling abroad, or more importantly, you're training the Cameroonian Special Forces in Man of War Bay, and you're trying to have a discussion with them as to why it's critical that they follow the law of armed conflict, why it's critical that they do not torture. And so by making this a very personal thing to them, and making them understand that their country will be held in what I refer to as the court of world opinion. So one of the biggest knocks on international law is always enforceability, right? but the court of world opinion will determine whether or not the rest of the world views your country as a pariah, as a violator of international law, whether or not they view your particular unit, as it did in Cameroon when an Amnesty International report came out the same time I was there training them, alleging this very unit had conducted torture. So by being able to make it relevant to them personally, not in a you could be held at a court someday, which is a fair enough threat, but also in them understanding that, is this how you want to be viewed by your fellow countrymen? Is this how you want to be viewed by your own families? Is this how you want to be viewed by your son or daughter when they ask you what you did during the war? And so this is all important to get to the relevance of it, so that there's an ownership and a stake in what we're talking about and why we need to follow this thing called international law.
Thank you so much. Maybe we can move now to Julie, and then we'll end with Hardy when Julie's done. Thank you.
Thank you, Yvette. Well, first of all, I want to apologize because just at the literal moment when I was starting to introduce myself, my toddler started banging on the glass door behind me. So sorry about that. And because of that, also, I didn't mention that I am also currently a visiting professor at the UN-mandated University for Peace in Costa Rica. And I have also taught at universities across the Americas on primarily international human rights law and specializing in gender rights. As part of the work, both my work at as a professor and at the Inter-American Court of Human Rights, and now currently at the Supreme Court of Mexico, I've taught both legal and non-legal audiences and mixed audiences. In terms of, for instance, in the master's programs at UP's, we have undergrads, it's interdisciplinary. So we have everything from government employees, social workers, people, undergrads in political science or international relations, so mixed audiences. As part of my work at the Inter-American Court of Human Rights, what we did also, aside from the primary work of the Inter-American Court, which is the resolving human rights cases, we did a lot of promotion of the standards to try to educate on the standards that the Inter-American Court of Human Rights issued, human rights standards. So this included students who would come to the court, both law students and non-law students. We had a program for ombudspersons. State ombudspersons would receive lectures from the attorneys at the Inter-American Court, and they also could be lawyers or non-lawyers. We also had members of NGOs come to the Inter-American Court to learn about the most updated human rights standards that the court has been issuing. Our court sees the Inter-American Court everything from grave human rights violations to violations that are more during democracy, so freedom of expression, LGBTQI issues, other women's rights, sexual and reproductive rights, etc. So the Inter-American Court sees a very, very large gamut, and members of NGOs would also come to the Inter-American Court and the Inter-American Institute, which is it used to be the academic side of the Inter-American Court, but it's split off. So with the Inter-American Institute of Human Rights, we work together with them also, and many times with interdisciplinary audiences. Also, we would be tasked very often to go to different states and talk to members of security personnel like the police, particularly on human rights standards. In my particular case, very often on how to avoid violence against women and how to, standards, for instance, on how to investigate such cases, what the collection of evidence should look like, how to treat the victims, etc. And also, as part of my work at the Inter-American Court and as part of an NGO, the Gaia Foundation of Costa Rica, I had the opportunity to talk to indigenous peoples about their rights in the Inter-American system and ILO 69. And with these communities, it was with, one was with this NGO that basically was trying to unite all of the indigenous communities under sort of a environmental program as well. But also the government of Costa Rica, because I was an attorney at the Inter-American Court, requested that I go to Indigenous communities to talk about the right to a prior consultation before issuing concessions. So all of that work I've been doing, well, I had been doing with the Inter-American Court, and now with the Supreme Court, I've gotten to talk to law students and non-law students about both international standards and Supreme Court standards in Mexico. So that's the work that I've been doing teaching. And I would have to say that I agree 100% with Greg that the most important thing to get across to whenever you're speaking to students of any sort, of any type, whether they're non-law, law, or whether they're already seasoned professionals that have a great career, is how is this relevant to me? Especially because since international law can be so far removed, perhaps, from the daily reality, and particularly in the United States, where I feel like it's not taken nearly as seriously as it needs to be taken. If you can make the human connection, I think that's goes a long way into making people care about what you're talking to them about. And also, I think I would add that as long as you're talking to them about something that you're passionate about, it's hard to go wrong, because if you feel like, well, I really want them to know this, I want to get this information to them, they catch on to that. They can feel your energy, and I think it engages them. So I guess I would add that. And obviously, we're going to talk about the methods next round. So that would be my 2 cents for now. Thank you.
Thank you. I have the pleasure of teaching international human rights law to upper level undergraduates and graduate students. So all my students have a public policy background. None of them have a law background. Some are also from the social work school or public health and what have you. So I usually have a pretty mixed group. I focus my work in on the role of courts in making international human rights law, and specifically within the context of the United States. So it's a really fun semester because everything I say, I get to counter it usually a few moments later. Really my job is to try to, as Julie and Dr. Noon already mentioned, is to try to make this real for them, because they could get very theoretical. I'm teaching from a case book, and especially in the beginning when I'm talking about the concept of human rights, it can get very philosophical. So I focus the work in a manner that tries to ground it. So I spend a lot of time talking about race and trying to step away from a Western framework. So I'll put the Western framework out there, and then I try to have my students critique it and see if we can't find even more helpful insight from other cultures and societies. And I also try to, at the end of class, come back to the point that international human rights, of course it matters, but what does it mean when it comes home? So my students spend a lot of time on things like Black Lives Matter. So we spent a lot of time last semester discussing that. So I try to make sure that it's not just something to be discussed in theory or discussed about some other country, but it's quite relevant here in America. And I agree with Vanessa that using real life problems makes the most sense. So I will use case studies, but I try to also bring in a lot of my work at Human Rights First with asylum seekers. So I bring in a lot of outside speakers. So people that can talk to, I have a colleague, for example, who was on the ground in Hong Kong during some of the protests that were taking place there in 2019 and 2020. And so he spoke about, well, what does it mean to have an international human rights law standard in Hong Kong? Does that actually mean something? I also brought in a former U.S. ambassador who worked on Rwanda issues during the Clinton administration to talk about, again, what do those standards mean in the midst of a crisis, in the midst of an emergency setting? And then the last thing I tried to do is take students into the field. So in non-pandemic times, I've been able to take students to Guatemala, and we work with a forensic anthropology organization. So there I'm trying to expose them to how an organization that's focused on science brings closure and advances the aims of justice for all of those families and survivors of the Guatemalan Civil War. So there I'm trying to sort of make it clear that the theory only matters when you can sit down with a community member and explain to them why we're doing this work. And more importantly, empower those community members, that you can't sort of walk in and believe, since you have the right principles, that gives you a license to do whatever it is that you wish. So we will spend some time working with this organization and going out to excavations, speaking to community members, doing a particular project for that NGO. So I think it's really important that when we teach this work, as we have talked about before, is to take the theory, make it real, and make our students wrestle with the questions. And my students always want to get to the answer. And I tell them that there's something to be said about wrestling with the question, in large part because there's usually not an answer, or not a very good one. So the rush to the answer may not be nearly as satisfying as they would like. And particularly for students who are coming from a different discipline where they're used to, there is an answer. I'm trying to say, there isn't one here, or my answer is going to start up with the words, it depends, which is really unsatisfying for a policy student who's been doing, stata or cost-benefit analysis. But it's important to start to get comfortable in that uncertain place that looks a little grayish and far from black and white. So I try to free them from the norms that they normally are wedded to and live in this world of uncertainty and fluidity, which drives them absolutely nuts. But we make it eventually.
Thank you so much. These are great points that you are making. So as you were giving your experiences to our audience, I jotted down some interesting points, and I guess we can maybe move into our discussion of challenges, and also maybe combine it together with the benefits of teaching international law to non-legal audiences. So I know that Greg, Vanessa, Julie, and Hardy, you mentioned about this method of maybe finding some real examples that can be studied, or maybe case studies, making it important to your students, why they should be interested in this issue, and actually making it relevant, as Hardy mentioned. So I was just wondering, since some of you had the experiences teaching both non-legal and legal audiences, what did you find maybe challenging in your work with non-legal audiences, or maybe it was easier to actually teach or work with non-legal audiences? And then also you can go in also the benefits. If you didn't mention that already, what do you think the benefits are for the community, for the persons who are learning this, how they can apply what they learn in their international law courses for non-legal audiences, and move it beyond the classroom? Thank you. So maybe we can start with Greg, and then move on to Vanessa, Julie, and Hardy.
Yeah, thank you, Vanessa. First of all, Hardy nailed it. It depends, right? The greatest legal answer of all times. And so in dealing with these different audiences, I think it's critical that we as lawyers, and look, you have a panel with immense experience here, but we're still lawyers. And as from time to time we get into this long esoteric answer, instead of kind of drilling down to the nut of what they want to know. They want to know yes or no, can we do this? And as Hardy rightly said, the answer is not always that simple, but we need to try to work them to that. Whereas opposed to teaching law students, they're more than happy to kind of swirl about and go through this longer discourse about how we got there. When you're dealing with people who maybe, and in the case of a lot of the militaries I've dealt with overseas, who maybe can barely read and write, having long thoughts about what Oliver Wendell Holmes may have said isn't really the way to go. So to jump to your second part of your question about the benefits, it's always better to have an informed population than an ill-informed population. We've seen that time and time again around the world. So the more they understand about human rights, or the law of armed conflict, or how are we supposed to treat civilians who just got caught in the middle of this thing that's going on. We don't even know what this thing is. Is it a non-international armed conflict? Is it terrorism? Is it whatever? But how are they supposed to be treated? How is the police supposed to react to them? How is the military supposed to react to them? And so really, I think one of the key ways, especially one of the biggest challenges, especially from a U.S. Man in uniform, is sounding paternalistic. So one of the key things that we've done over the years is making sure that we understand that, hey, look, here's what the U.S. did, and here's what we did wrong. Here's how we think we fixed it, and here's how we think the fix is working. And oh, by the way, we're not perfect. And so we're living through this as well. And I think that's been very helpful to show that we're willing to admit mistakes and have hard conversations about very hard issues. I guess the second challenge is, why does it matter? I know you're trying to make it relevant to me, Captain Noon, but why does it matter to me? And no one enforces international law. So I kind of give them a cafeteria of options, right? Okay, you don't like the law, you don't want to talk about law? All right, let's talk about political support and political considerations, both domestic and international. Let's talk about the pragmatic impact. The pragmatic impact of following the law of armed conflict is it keeps people alive. You'll have fewer friendly fire instances. You'll have good order and discipline. You'll actually accomplish the mission in a way that's sustainable. And if you don't want to go with pragmatic, let's talk about the moral high ground and your ethical capacity. The law of armed conflict, for example, is derived through centuries of law from every continent, from every religion, from every philosophical trend. And so this isn't just a white Western European thing that they came up with in Geneva. This goes back to the Code of Hammurabi. This goes back to the laws of Manu and the Bushido Code. So we really do have a wide, worldwide organic growth. And lastly, as that I put towards military people is, you have to think of it in future conflicts. Your responsibility isn't only for your soldiers, sailors, airmen, and Marines today. It's for future soldiers in the field. And if you're doing something wrong, if you're torturing people, if you're shading that line, in the future, there's going to be a soldier, sailor, and Marine that is going to be held and is going to be tortured, and they're going to say, look, you guys did it. You have this memo signed by this guy. So if you guys did it, all we're doing is what you guys did. And from my perspective, it's going to be a kid named Murphy or Rodriguez that's going to bear the brunt of anything we do in an expedient fashion today, that any military takes a shortcut.
Vanessa?
So to answer your question about the differences between teaching a legal audience and a non-legal audience, from what I've monitored and from what I've done, also as a law professor, I can say that law students sometimes spend a lot of time, as Greg mentioned, on the theory, on the theoretical part of understanding international law. Whereas non-legal audiences are much more practical, and most of the time we see individuals who become activists or human rights defenders out of need, and not because they necessarily hold a legal diploma. So it is important to teach international law to non-legal audiences, because these groups, these individuals, they often need to understand, they need tools to understand how to use rules that would help them mitigate destructive conflict. So it's not an exaggeration when I say that sometimes these non-legal audiences need these tools, need the understanding for their own survival and for the survival of their communities. But teaching international law to non-legal audiences is not only relevant in times of conflict, it also becomes important in times of peace. Often we get requests from CSOs, human rights activists, that want to have a better understanding as to how to question and repeal laws that somehow place restrictions on the advancement of their freedoms, affecting specific groups and specific individuals. Sometimes cultural patterns, cultural practices place unnecessary restrictions on specific groups. So that's the importance of teaching international law. We're basically facilitating tools for protection and also for the defense of rights. In some international law, teaching international law to non-legal audiences can become an additional shield of protection to vulnerable populations. Teaching international law helps students understand that their governments are obligated by international norms to be stable and more responsible actors. Teaching international law helps communities become aware as to why and how they can hold their governments accountable for any past or present wrongs. To me, that's important. That's what is important about teaching international law and other types of law to non-legal audiences.
Thank you. I'm sorry.
No, that's okay. But the only, I guess, the only recommendation that I don't know if it's a disadvantage, but one recommendation that I could make when teaching international law to non-legal audiences is we should always try to have experts, trainers that have a solid background of the host country's legal framework. We need experts to be more acquainted with the different cultures and the different understandings. And I also recommend having experts that speak the same language as a non-legal audience. I think those are some of the recommendations I have made when I've attended these trainings, because sometimes we can lose important information when a trainer doesn't speak the same language, or when he or she's not too acquainted with the legal framework that this non-legal audience comes from. That's all.
That's great. Thank you. I guess we can go to Hardy.
So in terms of challenges, in trying to teach international human rights law as I do to non-legal audiences, I think the first one, the thing that comes to mind is it can be inaccessible. The language, just reading a case, if you're not accustomed to do it, it just seems really foreign and distant. Even if it's in your own language, it can seem incredibly inaccessible. So working through the barriers of language and getting to the nub of what it is that, like I said, I focus on the courts. So trying to get to what's at stake here. The discussion is about whether we should put a child to death. What does that really mean? And then I try to bring in an example from my real world where I was representing a child who was facing the death penalty, and what the court is wrestling with here, so that it becomes real to them that you have a 14-year-old who has, killed a loved one. International law says something about that. So does your domestic law. How do we work through that? And why does this matter? The second challenge is the lack of accountability. That my students sort of go, well, you signed on to this international agreement, so you didn't do it. So the following is going to happen to you. And I go, well, maybe not so much. So for them, it's sort of like, but the law says this is going to happen, correct? So I have to sort of get them a little bit more comfortable with it. There's not an always if-then. It might look like that, but it doesn't always play out that way. And then this idea of assent, right? That I'm holding myself to the standard, therefore this system works. And then there are others who don't hold themselves to that standard. And so there's a fluidity there that I think is also new to my students. In terms of benefits, I think the beauty of teaching international law to non-international law students is it democratizes the material, right? It allows you to envision and see yourself in it. So I try to say, whether you are a Guatemalan living in a Mayan community, or from Haiti as I am from, or some other part of the world, there's a place for you here. And it doesn't matter that you're not a lawyer. You could be in the corporate sector, the NGO sector, the INGO. So I bring in a speaker from Google, for example, to talk about why human rights matters to a corporation. And I also try to make sure that most of my speakers are people of color, and that I have gender diversity, because again, I'm trying to make the point that although our discussions will begin in the philosophies of a Spanish monk, I assure you, it evolves to the point that it matters to all of us in the room. The second thing is, I want my students to be empowered to have voice, right? To understand that sometimes you might bring a lawsuit to try to hold someone accountable and you may lose, but there is something to be said about getting up in front of a tribunal and saying the name of your loved one who has been lost, who's been forcibly disappeared. There's something to be said about having your moment in the public because it matters. That loss matters, that injustice matters. And although you may not necessarily get the result you want, let's not underestimate the power of catharsis and the power of voice, because then the law sees you. So I try to give my students that sense of hopefully maybe meaning, or at least point them toward that. And then I think the other benefit is I can hopefully help the students understand what the law can do, and conversely, what it cannot do, so that we have realistic expectations, so that we don't believe that every single problem will be resolved by either an international agreement or a customary practice or a jus cogens principle. That there are things that the law just cannot make happen, but there are some things it can. So in that sense, they could look to other arrows in the quiver to figure out, okay, well, the international human rights law will stop short here. So maybe I'm going to use naming and shaming to advance the ball. So I want them to have a full sense of what that landscape looks like and its limits, and its power.
Well, thank you so much. Julie will be back with us soon, so we can come back and ask her that question. But while we're waiting for her to return, maybe we can move on to our next question. And that would be, and actually, before I do that, I wanted to say that you are making a lot of great points, actually, to make that international law teaching as inclusive as possible, looking from different perspectives, making I guess what can you do with this international law? What are the limits, but also how can you use it to your advantage? I think those points are great. So let's move on to the next question, and is if our audiences are who are watching this tape and or this session would like to maybe get involved in teaching non-legal audiences, what's your advice? What's out there? How do you think these audiences can get involved in teaching, either on community level, their own communities, or any other? Thank you. So maybe we can start with Vanessa and move to Greg and Hardy.
Well, in the case of training funded by DRL and other bureaus within the Department of State, they usually publish all notice funding, known as NOFOs, at the Department of State and U.S. Embassy's websites. So I encourage CSOs, activists, defenders to often check those websites. There's a lot of information that sometimes people miss. I also encourage visiting websites of organizations that provide legal training abroad, such as the ABA and its respective country chapters overseas. They often look for new names and profiles they could add into their databases. In my view, there are many US NGOs that want to train leaders in foreign jurisdictions on a variety of issues, and they are often short in experts. Personally, as I mentioned before, I always recommend individuals who have a solid understanding of the host country and its legal framework and speak the same language of the non-legal audience he or she will interact during the training. So if you feel like you meet those requirements, if you feel passionate about a specific topic, do some research online, not only government websites, but also NGOs, think tanks. There are always projects available.
Yeah, so what I would add to that, and excellent ideas, Vanessa, what I would add to that is really, Beto, kind of what you hinted at, getting into the local level. So volunteering at your local high school in the United States, I know in other places it's referred to as college, but that age group 15 to 18, volunteer at the local high school with their model United Nations. Mm-hmm. In the United States, we have both IB and AP curriculum. Volunteer to guest lecture at your high school's AP courses. Guest lecture at the local community college or local college if you have one in the area. People who are watching this have an incredible amount of experience in international law. And you may be living somewhere, maybe not, but you may be living somewhere where you're the only one. You're the person with the most experience. And what you can bring to the local schools would be immense. You don't have, I mean, you can seek to adjunct. Both Hardy and I have been adjuncting at law schools for a very long time. And that's great, but not everyone has that ability for that commitment. But speak at the local community organizations. In the United States, you have Rotary, Kiwanis, Lions clubs. They're always looking for guest lectures. So if you can go in and guest lecture about something that you've done, something that you've applied international law, then that's going to help grow the understanding of international law. So when there's a national debate or an international debate involved, you will have educated that group of people just a little bit more.
To add to what Vanessa and Greg have already mentioned, I would say there are avenues with local, your nonprofits and NGOs to get involved. I mean, recently, I saw this picture on Twitter of Haitians being allowed to enter into the US, Haitians that had been previously subjected to a policy under the last administration called Remain in Mexico or the Migrant Protection Protocols. And there was a large gathering of Haitians surrounded by this Haitian American lawyer. And she's doing, what we call in our world a KYR, Know Your Rights session. So there she is, masked up with her visor and holding forth in the middle of this courtyard. And that the power of that spoke to me that you don't have to be a specialist, but you can know something. You, as Vanessa said, if you're part of that community, you speak that language, those Haitians are likely to listen to her because she is one of them. And she can give them guidance, whereas they're navigating a new country, new language that probably has suggested to them that a country has suggested to them that they don't want them. And she could at least say, I've been on the other side, and here's what you might have to contend with. And she has resources that she could point them to. So I think it's really powerful to recognize that there are things in your local community, whether it be nonprofits or NGOs, that you can connect with. And you can either learn the subject, because we're lawyers and we learn lots of subjects and we learn them fast, or you already have that knowledge and you can dispense it. And even if it's just a little knowledge, the people that you're speaking with are really going to appreciate that from you because you know more than they do and you're making a true difference in their lives.
Thank you. Welcome back, Julie. So we are discussing any ways that our audiences maybe can get involved in teaching international law on their local level, or any other ideas that you might have from your experience, in case if they would like to participate or teach others about international law.
Okay, would it be all right if I go back to the last questions? Is that okay?
Yes, I was saying that maybe after you address this, we can go back to the other question. Either way, you can take it. You can take it all at the same time. So we were talking before. Then we were talking about the benefits and challenges.
Yes. Well, I'm sorry if I repeat some of what my colleagues said. Obviously, I had some internet issues there. I think the greatest challenges are, well, twofold. One is tailoring what you're teaching to the intended audience. And this ties a little bit into the question of what benefits are there to receiving instruction in international law. Clearly, what you might impart to a group of undergraduate students will be in broader terms, like why should this be something that they care about, or how could it impact something that they might eventually want to become involved with later in their careers. So much broader terms, you wouldn't go into the nitty gritty of how to submit a petition before the organs of the inter-American system, which we would do if you're talking to someone who works for an NGO that litigates before the inter-American system. And obviously that would be different than what a lecture would look like if you're talking to an Indigenous person about his or her rights, and how he or she could go about defending those rights before the organs of his or her own state. and what that means in practical terms for their communities. So that would be the first thing. Obviously, tailor what you're doing to what you're teaching to the intended audience. And second, make that information as accessible as possible. Keep it simple. In particular, I think it's more difficult to teach to non-legal audiences than to legal audiences, because when you're speaking to a legal audience, perhaps you assume that there's basic principles that they will be aware of, legalese that they will know what you're talking about when you say it, and you have to make sure that you don't fall into that when you're speaking to other types of audiences. You make no assumptions, because there's no reason why they should have any basic knowledge of international law principles. And in terms of method, well, first of all, I guess something a little more practical that I've seen works very well is when you set up at the very beginning of a lecture, like, what is it, how is this class going to be structured, and what is it that I should know by the end of the class? If you can set up those objectives at the very beginning. And second, I'm sure this topic came up a lot, storytelling. If you can tell a story, a human story, that's what gets people interested. If you can tell a human story, and show examples of cases where international law has had a real impact in people's lives. I get really excited telling people about cases of the Inter-American Court where it led to changes in the constitutions of the states, or in the laws of the states, or in the practices of an entire part of the government, or the way that something is run or something is done. That I think that's what really makes them pay attention. Like, oh, really, one judgment led to all of that. I think that's what gets people excited and thinking maybe this is something that is worthwhile. I try to ask lots of questions, encourage discussion, asking students how they would resolve a particular case if it was before them and they were the judges of the courts. I think that also asking questions at the very beginning also sort of gives you an idea of where they are if it's a non-legal audience, and where perhaps you can start from what level. Like, do they absolutely know nothing about international law, or do they already have some background? You get that a lot from the sorts of questions you can ask at the very beginning to generate discussion. Also, I think repeatedly emphasizing and enumerating important points, like, you should get 3 things from this case or 5 things from this case, and make an emphasis on 1, 2, 3, 4, 5. If you can make those breaks while teaching, I think that helps a lot. The use of videos, the use of pictures. I still remember from my undergrad days, I had a wonderful professor, Sam Stafford, at the University of Florida, who, when talking about how courts sometimes ducking by the court, he drew a big duck on the whiteboard. And I had another great professor, Paulo Carozza, at Notre Dame, who, when talking about international organizations, drew a picture of Pinocchio because it wasn't a real boy. So talking about how some IOs have the trappings of sovereignty, but not, it's not a real boy. So those things that I still remember to this day. I mean, I was a law student, and I recall those great classes. And at the very end, I think it's really important to try to give them something that they'll keep thinking about once the class is over. Especially if you can tell them about emerging issues, or cases that are yet to be resolved, or ask them to think about the ways certain standards set out might impact on other types of cases. For instance, in the Inter-American Court, we have a case on in vitro fertilization. So what the court said in that case perhaps impact abortion rights, because it's linked. So if you can sort of pique their curiosity, I think that is something that'll keep them engaged. And I think, like Vanessa said at the very beginning, the use of hypotheticals in case studies. It's when they have to apply the law to a set of facts, I think is when it becomes a little bit more concrete and real to them, and not just stays in the abstract. And in terms of the benefits, well, I heard a little bit when I was trying to get back in, someone was speaking about Know Your Rights session. I think Greg was speaking about Know Your Rights sessions. I think obviously the first thing that's the main benefit is that we all know what our rights are. But beyond that, I mean, clearly, if you're talking to people who are supposed to implement human rights standards in the day-to-day work, they have to know what those standards are. So there's a clear, direct link between the benefits of knowing international law and what we're actually doing on the ground. And besides that, and I think particularly for the United States, I think it helps to start transforming America's vision of its own role in the world. The feeling outside of the United States is that the United States sees itself as separate from the community of nations and not bound by the standards that it demands from other nations. So if we can get US lawyers to sort of look beyond the horizon of our own borders, I think that's a really good thing to do, because international law impacts foreign policy, asylum law, refugee law, environmental law, and frankly, the United States has pretty weak protections of economic, social, cultural, environmental rights, the rights to healthcare, education, adequate food, water, shelter, environment. And I think, frankly, a lot of people have greater protection for these rights outside of the US. And I think we can benefit from those experiences and to learn about what people are doing across the ponds, multiple ponds that we have.
Thank you so much. We are running out of time, so we have to kind of wrap it up. So I just wanted to thank all of you. And Julie, thank you so much for trying to get back and giving your perspective. Thank you so much. And thank you so much, the panel, for participating in this session. Thank you, the audience, for listening to us. I encourage the audiences to come up with some, if they have questions, or to jot down the questions, because we will have the continued conversation session after this. So please join us at the CT after viewing of the segment. The panelists will be there, or some panelists will be there to answer your questions. Thank you so much for all your participation or your information. Thank you.